Good morning. Are you Robert Trahan?
Yes, ma'am.
And Mr. Trahan, in cause number 25 DCCR 1094, is charged with the state jail felony offense of unauthorized use of a vehicle from June 3rd of 2025. That indictment alleges a prior offense of accident involving injury or death on October 16th of 2017. And then after that was final, convictions on October 17th of 2022 for evading arrest or detention with the use of a vehicle and also possession of a controlled substance, a second-degree felony, making this, if all of that's true, for punishment purposes, a second-degree felony offense. And then in cause number 25, DCCR 1317, charged with possession of a controlled substance. Let's see. Also a state jail felony, has those same prior offenses listed, convictions listed again for punishment purposes. That would make this a second degree felony offense if true. And what is the announcement?
Your Honor, he's instructed me that his family has hired a lawyer out of Houston to represent him, and I don't think he's had time to file with the court, and so I asked that it be reset for him to make those arrangements. That's what he told me.
So whoever that is hasn't filed anything yet to show that he represents you. And so what I'll do, Mr. Trahan, is reset your case, a normal reset, which is about 30 days or so.
Yes, ma'am.
Mr. Parker will remain on until we get that information from that attorney. If for some reason that didn't work out or something didn't happen and he wasn't hired, then Mr. Parker will remain your attorney at that point, okay?
Thank you.
All right. Yes, sir. You can go back with the bailiff. Good morning. You're Norberto Armenta,
Yes, ma'am.
and will your client waive the formal reading of the indictment?
So, he will, Your Honor.
Let me,
And Judge, if we may proceed on what I have numbered as 1, 2, and 3, my position on that is it's the first paragraph, the second paragraph, which is a jurisdictional paragraph to get us to the DWI third, and then a regular felony prior.
Okay,
I see.
so technically two
Technically 2. I just
two counts with
didn't know
the
if-
second
how
paragraph.
it kind of looks like a paragraph on its own, but it's just jurisdiction.
Okay, and so in cause number 25, DCCR 0168, you're charged with the third degree felony offense of driving while intoxicated, third or more. That's from April 25th of 2024. The indictment alleges you were previously convicted of driving while intoxicated February 5th of 1998 in Harris County, Texas, February 6th of 2008 in Harris County, Texas, and then again September 8th of 2023 in Harris County, Texas. And then the second count in this indictment alleges that you were previously convicted of possession of a controlled substance, second degree felony, June 24th of 2004. And how do you plead to that charge?
Guilty.
And are all those prior convictions that I read out for DWI as well as the possession of a controlled substance true?
Yes, ma'am.
Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
I have here on the computer tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 12 years in prison. And I want to make sure you understand what that means is you're leaving your punishment up to me. And as long as I don't give you more than 12 years in prison, then you can't appeal. If I can give you 12, I can give you less. It'll depend on the information that's brought to me at a sentencing hearing.
Yes, ma'am.
You have an absolute right to have a jury come in and determine 2 things. The first is to determine if you're guilty or not, and then you could leave your punishment up to that jury. If we go forward this way, you're waiving that, and is that what you want to do?
Yes, ma'am.
It shows also as part of this agreement that the state will dismiss cause number 25, DCCR 0169, and it will run concurrently with any other felonies that you are currently serving time on. Is that your understanding?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Without objection.
It's admitted. Is there any evidence that Mr. Armenta is not competent?
Not a word, no.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That will give me more information about you, your case, and then we'll come back later for sentencing, right? You can go back with the bailiff.
Your Honor, just to be clear on the paperwork, it reflects we're not requesting probation, we're requesting a five years.
I saw that, yes, sir, thank you. All right, you can go back with the bailiff.
I'll be out to see.
All right, you're Kaylin Salzar. And Ms. Salzar is on probation in cause number 24, DCCR 2234. And that is for a misdemeanor offense, or a case that was reduced to a misdemeanor. It's an unadjudicated probation. She was placed on that probation April 21st of this year. And it was a criminal mischief that was reduced to an attempted criminal mischief. A motion to revoke has been filed, or motion to revoke unadjudicated probation. It alleges a DWI from August 23rd of 2025. It alleges a failure to report in August, failure to perform community service, behind in court-assessed fees, that she admitted to using alcohol in violation of her probation, August 23rd of 2025, that she has not completed a cognitive thinking class as ordered. And in addition, we have a pending felony case of assault on a peace officer with an offense date prior to her getting the probation in this case. And so that's not alleged, and it's standing, I guess, on its own at this point. Mr. Kemmler has filed a motion asking that I set a bond in the misdemeanor probation case where she's on an unadjudicated probation. Mr. Nichols, what's the state's position on that?
Your Honor, in addition to the two cases before you, she has two separate.
Right from the start, Judge, is all business. Notice how she methodically lists every prior conviction. That's not just formality, it's building a legal foundation each prior. Makes the new charge heavier, possibly doubling the sentence range. The calm tone here hides a storm of consequences.
DWIs that are pending lab results that have not yet been filed. One is from March and predates this probation. One is from is what's listed in the motion. It looks like the only thing holding her is the bond on this case, and if she's in light of those arrests and what's alleged in the motion, if she's going to be granted a bond, I ask that be interlock. And
I would suggest she not be allowed to operate a motor vehicle, period, instead of an interlock. But if she does have the interlock, I don't think she needs to be at all. But she wants to go into rehab, Your Honor, and that's really the purpose of me trying to get her a bond. Where have you talked about?
Well, and here's the thing, you don't get to pick all of that. She's on probation, so that has to go through probation. In addition, we have another case pending that, depending on the length of everything, I'm not just going to put off. And so obviously if there needs to be some rehab, then I'm all for that under the right circumstances. But if you make a bond, you can't just go off somewhere without it being approved by probation and ultimately by me, so that we know what that is, where it is, and what that means with regard to that assault on a peace officer case.
That's her intent. She does recognize that she has an alcohol problem. I've talked to her extensively about that.
Hold on a second. So, Mr. Nichols, any other input?
if it's not going to be, and I agree that maybe her not driving at all is probably the best course, but there needs to be some sort of monitoring, like a scram or something along those lines, Your Honor.
I agree. So what I'm going to do, Ms. Salzar, in cause number 24, DCCR 2234, is to grant that request for me to set a bond. I'm going to set the bond at $10,000. Condition of that bond is you are not allowed to drive anything, no vehicle, period, ever. You will be required to wear a scram device. Obviously, if that tests positive for alcohol, then you will be in violation of your bond conditions. That bond's going to get raised, and you'll be able to wait all this out while you're in jail while it gets sorted out. Do you understand? Any other conditions?
I think that should cover it, Your Honor.
Okay, and so what I'll do then is we'll reset, a normal reset, and see what we need to do on this, obviously, as well as the other pending felony.
And then she needs to report to her probation officer as soon as you make bond.
Yeah, you're still on probation, so go straight to your probation officer, talk to them about what you need or can do, and then go from there. Okay.
And stay in touch with your bondsman.
All right, you are Robert Isaiah Paredes?
Yes, ma'am.
And Mr. Paredes is on probation in cause numbers 16-24053, that one for prohibited weapon possession, 20-35328 for aggravated assault causing serious bodily injury, and 20-35329, also aggravated assault causing serious bodily injury. Was in court previously. Entered pleas of true to counts 1, 2, 3, and 6. I've received an updated pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Any additions or corrections?
Nothing with that.
Any testimony with regard to any of the other allegations? Mr. Smith?
Judge, we have each person here for.
I'm sorry, I can't hear you.
We had the probation officer here, if you'd like to hear from him. I believe that, yes, I did address.
I mean, I have what he put in here, but I'm asking if there's any witness, if you want to put in on any testimony for the counts that were not pled true to or not.
So, Jake.
I would ask him a few questions if the state's not going to call him.
So I guess we will do.
All right, Mr. Patton, if you'll please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Go ahead.
Mr. Paredes was ordered to perform community service, and has he completed all of that and provided verification to the probation department?
He is not, no.
And did he appear for alcohol or drug screening on June 18th, June 25th, July 2nd, July 5th, July 21st, 2025?
What were those dates again?
June 18th, June 25th, July 2nd, July 5th, July 21st.
So June the 18th, he did not show. June the 25th, he did not show. July 5th, he did not show. And July 21st, he did not show.
That's what it's.
I guess I want to know with regard to community service, obviously what has he done out of any of it, if any?
Your Honor, in cause number 16-24053, he has completed 169 hours out of the originally assessed 300,
Okay.
which leaves him with 131. He last performed community service on April 4th of this year. He worked with our work crew at my Beaumont office. He has not performed any of the community service in either of the other two cause numbers.
Okay, thank you.
This one hits differently. The judge doesn't have to say much. Her pacing says it all. When you've seen the same defendant across decades, the courtroom becomes a mirror, not just of law, but of life spiraling in circles. How many chances do you give before justice has to step in?
Mr. Kimler?
Shouldn't the community service be concurrent in all three of the cases? In other words, the community service that he's done in one case should transfer and be credited against community service required in the other cases?
It is, yes, you're correct.
So he would have 169 hours in each of the three cases
Yes.
credited, is that right?
Yes.
And is that so even though he was already on probation on one and then we gave him probation on two after that?
It is typically how we do that, Your Honor. We typically will give them credit for community supervision on any of the cases they're doing for us, regardless of when they started supervision.
Community service.
Yes. Sorry.
May I proceed, John?
Yeah.
How long have you supervised in Mr. Patton?
So I'm a unit supervisor at our department. I've seen Mr. Paredes on numerous occasions for administrative hearings, case staffings, and when I've held down a caseload when we've been in between officers.
But you have some familiarity with him?
I do, yes, sir.
And during the times that you supervised him directly, has he maintained proper demeanor with him?
Yes, sir. Yes.
Proper decorum, all those things?
That is correct, yes, sir.
And should he be continuing on probation, he would not be the supervising officer, that would be someone else, is that right?
That is correct. I would not be supervising him.
Well, let's say, I suppose you acted as a supervising officer at some point in your career at the probation department, is that right?
That is correct, yes, sir.
Assuming, let's just speak hypothetically, if you were a supervising officer again, would there be anything about Mr. Paredes that would cause concern to continue to supervise him as far as his demeanor and decorum and attitude towards the probation department or personnel?
Hypothetically, no, not concerning those items.
Who was his supervising officer?
His supervising officer was Alexandra Ariano. Ms. Ariano went out on maternity leave and elected to stay home with her child. And so we've since filled that vacancy with a new officer.
But she was the one that was, I guess, directly supervising.
That is correct, yes, sir.
You have access to her records, is that right?
I do, yes, sir.
Is there any indications in there about some type of mental health referral, anything of that nature?
No, sir, there's not. Not that I've come across.
And nothing in the records that indicate that there's ever been any type of mental health assessment or mental health recommendation for Mr. Paredes, particularly not for schizophrenia or anything like that, but perhaps depression or...
Not that I've come across, no, sir.
That's what it is.
No further questions.
All right. So, Mr. Paredes, it shows here in this updated pre-sentence report that one of the things you told Mr. Patton was that you had been on probation since you were 18 and you just couldn't do it anymore.
Yes, ma'am.
That's true. And then you said, I'll take a safe P. I feel like prison's going to make me worse and blah, 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 but I feel safe P is the best thing for you. So tell me what you're asking for and tell me why.
Well, at the time when I told him that I couldn't take probation anymore, that was one of the times where I was just feeling real down and depressed, from everything that's going on in the past, with me being shot and stuff like that. I was shot in my neck and my arm, so since then I've been having real bad PTSD, real bad depression, bipolarness. So, there's some days where I'm good, some days I'm not, some days I wake up on the wrong side of the bed from having nightmares, and some days I'm just as happy as I can be. So from that point on, at this point, I know since being in jail now, this isn't what I want because it's just hurting my family, hurting my daughter, and being around the people that's around me, being around murderers and rapists and aggravated robberies and all that. It's just a bad environment for me, and it puts me in a bad mood. Puts me, in a bad mindset, I guess you can say. And I did speak with the counselor I had that they assigned me for probation, and I did tell her those things, and they did recommend MHMR, but I never went just because I felt like it was I felt kind of low, of thinking I would go to MHMR, because
Stigmatized.
Yes, sir. So at this point, I don't want to go to jail or prison. Feel like being in here, sitting in here, has helped me realize that my life is on the line and it isn't a game and it isn't a joke. And but I do need help mentally. I was prescribed Zoloft the last time I was in here due to my PTSD, but I never took it. Because I heard really bad things about it. But now I'm starting to realize maybe I should be on Zoloft just to control the urge of smoking weed and that kind of behavior.
I could ask him a few questions, John.
Sure.
I'm
I'm
sorry.
Best you can, raise your right hand. Do you swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Go ahead.
Explain those facial tattoos to the judge.
This tattoo right here is my daughter's birthday.
Here's a key legal moment most people miss the waiver of a jury trial. When a defendant pleads guilty under a cap, they're trusting the judge completely. It's a calculated risk. Skip the jury hope for mercy. But in this court, mercy often has a limit.
11/14/2017, and this is 9/16/22 is the day my cousin killed himself. He shot himself in the head. This was right after my uncle had passed of cancer, and my cousin who just passed away, his dad, my other uncle, had just passed due to cancer as well. That's why I turned myself in a week later after my warrant had came out. This tattoo on here is a heart and a music note. I got that for my ex-girlfriend, just you know, being done at the time.
No gang affiliation?
No gang affiliated tattoos on me.
And you did turn yourself in on the warrant?
Yes, sir. I did turn myself in.
How are you maintaining employment when you're out?
Oh, I always held a job. Always held a job, even if it's working at Whataburger.
What was your last job?
Shipley's Donuts was my last job to maintain, because I got laid off. I was with Bechtel. I was a carpenter for Bechtel for about 1.5 years.
At the LNG plant?
Yes, sir.
LNG terminal?
Yes, sir.
What were you out? You were a carpenter?
Yes, sir.
Scaffold builder? What were you?
We were doing woodwork, building decks and carports and lunch tents and that nature.
And as far as being shot, that actually, I know the court, in looking at his criminal history, these are serious cases as far as the aggravated assault, serious bodily injury. You were actually shot during that interchange, is that
Yes,
right,
sir.
by the other people?
Yes, sir.
And you had returned fire?
Yes, sir.
That's not
I
what,
understand, Your Honor, but it's not, I don't want the court to think,
He-
I'm just looking at it, and I'm not trying
my
to.
understanding from the version in the pre-sentence report previously, and
I didn't represent him.
my recollection of it actually, because it's not good when I remember you. The fact that you were already on probation for a felony,
Right.
and then you came in and you admitted that you went there to shoot, you went there to go shoot Christy, but, which is your child's mother, right? That's not true? No? So did you mean to go shoot the 2 girls that got shot, Alexis and Taylor?
No, man.
Who'd you mean to shoot?
I didn't go there to shoot anybody.
I think as he explained it to me, he was going there to meet for sexual purposes, the 2 girls, and when he got there, he was set up in the parking lot, and then by other people there, by people who were gonna rob him, and in the course of that, there was a gunfight. But he wasn't going there to shoot anybody.
All right, well, that's
He was
again-
going there for an illegal purpose,
that goes against everything that was said and everything that he agreed to back then, because,
That's correct. We were getting ready for trial on this case.
Yes.
He was the aggressor. He was the one that fired first. And had he been a better shot, Alexis and or Taylor might
Sure.
have been killed, but he was there to go kill Christy.
I didn't represent him in
okay,
that, so I don't
all
know.
right. Anything else?
Big tone shift here. Now we're moving from sentencing to bond review, basically deciding whether someone deserves temporary freedom. Watch how the judge switches gears, same calm. But now the stakes are about trust. Can she trust this defendant not to vanish again?
All right, Mr. Smith, argument?
Judge, I would agree with the probation that I believe he's only asking for safety now simply because it's the only alternative he sees to prison. I don't think he's sincere about it. We have given him chance after chance after chance, and he has squandered, wasted, and even though he's a nice guy when he shows up, he does what he wants to do. That's evidenced by the jail reports that shows that they tell him to go back to his bunk and he just gets in the shower with his jumper on. And then when they write him up about it, then he says, man, fuck you. He has zero respect for authority or doing what's right, what he's supposed to do. I think prison term is appropriate in this case. The PTSD excuse is weak. He was the aggressor in the initial contact. And you can't claim that, well, I feel bad because I got shot by somebody who was defending 2 other women. So I would ask for pen time in this case.
Anything else, Mr. Kimler?
Well, it's difficult for me to address always with these jail incident reports without having the opportunity to cross-examine the person that made the allegations. So I would ask the court to consider the fact that that's not subject to, those allegations aren't subject to the rigors of cross-examination. But I think that on Mr. Brady's behalf, struggling with depression is a serious matter, and I know, and I respect Mr. Smith's looking at this as a way of somebody just volitionally, or somebody just deciding to be stubborn and self-centered and not complying, but depression is a serious.
This is fascinating. She's pausing the entire process not to punish, but to verify that's the human side of the courtroom. Few see hesitation. Judges carry the weight of what if I'm wrong. Every reset is a small act of caution and compassion.
Problem, he has struggle with that. I think that's indicated by the limited mental history that we have. There is no new offense allegations in this. These are administrative violations. Of course, those are important, especially reporting. But because of the seriousness of these cases, I would ask that the court give them at least one more chance with the aid of mental health, maybe safety, but also as a follow-up if he gets out to follow up with Spindletop to address not only any substance abuse problems, but any underlying mental health.
Here comes the toughest kind of case, relapse while already on probation. Should she get another chance or face full consequences? Let me know in the comments what's fair here, rehab or revocation, because this one divides even experienced attorneys.